Angel, and in this video we will talk about the laws regarding rights to child custody in North Carolina. When going through a divorce, it's hard enough having to adjust to life without your spouse. On top of that, many parents also have something else to adjust to, their new life with their children. Joint custody situations are great when your ex lives nearby, but what if your spouse moves out of state? Well, to combat parental kidnapping done in an effort to obtain a new custody decree in another state, North Carolina has adopted the Uniform Child Custody Jurisdiction and Enforcement Act. This act is an attempt to bring a set of standardized jurisdiction and enforcement rules, and a version of this act has been adopted in every state. However, it is wise to compare the act as adopted in another state, if it's relevant to your case, to determine if there are any different modifications of that act by that particular legislature. The Act provides 4 bases for jurisdiction over child custody matters. North Carolina has jurisdiction if, number 1, if North Carolina is the state in which the child has lived for 6 months prior to filing the custody lawsuit. This is called the home state. Or if North Carolina had been the home state and the child's now absent because he or she was removed by the individual seeking custody. Number 2, if it is in the child's best interest because the child and or one of both of the parents have a significant connection with the state, and evidence relevant to the child's present or future care, training, and relationships is available within the state, and a court of another state does not have jurisdiction. Or number 3, if a child is physically present in North Carolina and has been abandoned, or an emergency situation exists. Or number 4, if no other state would have jurisdiction under the Act, or if another state declined jurisdiction, then it's in the child's best interest for North Carolina to assume jurisdiction. Keep in mind that while the Act will prevent your spouse from relocating with your child in a non-emergency situation during divorce proceedings, the other parent may still be granted out-of-state custody of your children if they can prove they lived in that other state for at least 6 months or have significant connections to that state, including family, friends, or other connections. If your ex wants to relocate with your child and there is already a custody agreement in place, they will first need to modify that agreement before they can move. If they do not first modify the agreement and interrupt your custody schedule as a result, you can file a breach of contract action or a contempt motion against your ex. If your ex moves out of state with the children for the purpose of evading the North Carolina courts, then you may qualify for what is called an ex parte custody order, which is an emergency custody order. If your day in court comes and your ex has granted their wish to move to another state along with custody of your children, you can still maintain a meaningful and loving relationship with them. In many child custody cases involving relocation, parents may still have joint custody of their children. They may change their schedules so that the number of visits is less frequent, but the time spent with their children is longer and of higher quality. A great example of this is children who spend the school year with one parent and the summer with another. With the benefits of electronic communication, you can also continue to parent your children without being physically near them, using FaceTime or Skype or playing online games, helping with homework online. These are just a few of the ways you can continue to have quality time with your child. You can find further information on the videos on our website, rosen.com. There's other great resources to help you with your case. I'm Lisa Angel with the Rosen Law Firm. Thank you for watching.